The UK Modern Slavery Act of 2015 was established 7 years ago and was hailed as a pioneering landmark piece of legislation. However, the analysis of its results after 7 years are, while disappointing, very instructive and will allow the introduction of corrective measures by the international community. An example of an analysis of the present UK legislation, the Business and Human Rights Resource Centre report 2021, entitled Modern Slavery Act, 5 Years of Reporting Conclusions from Monitoring Corporate Disclosure, states the following, quote, the provisions of the UK Act itself, based on a requirement to submit a trifling level of reporting which has not been monitored or enforced, has failed to drive systemic corporate action to expunge forced labor, even in high-risk sectors. The Act has raised awareness of the prevalence of modern slavery and encouraged a cluster of leading companies and investors to do more. But ultimately, our analysis of 5 years' worth of statements in the Modern Slavery Registry has revealed no significant improvements in the vast majority of companies' policies, practice, or performance. Instead, lack of enforcement of the reporting requirement itself and lack of mandatory reporting criteria has led to dismal results. End of quote. In tonight's webinar, we will base our discussion on a recent expert report entitled An Opportunity for Impact Report, Recommendations for Regulating Modern Slavery in Supply Chains to the New Zealand Government, introduced by Dame Sara Thornton, DPA QBM, then UK's Independent Slavery Commissioners, which offers very clear recommendations to more efficiently enforce supply chain controls. This report, available online, modernslaveryrecommendations.nz, and in the handouts of this webinar. Dame Sara Thornton, in her introduction to this document, emphasized that, I quote, while modern slavery is perpetrated by criminals, human traffickers, and ruthless opportunists, it is enabled by lax governance, ignorance, aggressive commercial practices. While legislation is no silver bullet, it is the most powerful method of forcing greater corporate responsibility at scale. End of quote. The report underlines that a recent shift among international experts, instigated by the apparent lack of effectiveness with purely self-regulatory mechanisms, encourages the introduction of new legal mechanisms to go forward from a voluntary to prescriptive or mandatory approach. Dr. Natalia Szablewska, another author report, lawyer and social scientist with 20 years experience spanning the public sector, governmental and non-governmental organizations, and academia in 5 countries. She is currently professor in law and society at the Open University in the United Kingdom and holds further academic affiliations in New Zealand, Australia, and Cambodia. Natalia specializes in public international law and human rights law with a particular focus on corporate-related human rights responsibilities. She is the chair of Australian Lawyers for Human Rights, Business and Human Rights Committee, and a member of the Modern Slavery Leadership Advisory Group to the New Zealand government. And now, Professor Natalia Szablewska, looking forward to listening to you from Great Britain. You have the floor, please.
Thank you so much. Once again, thank you very much for the invitation. I'm delighted to be able to provide my commentary on the theme of today's seminar along Sara and Rebecca, and more specifically on the recent developments in this space in Aotearoa, New Zealand. And I really will be building on what Rebecca has said, and to some extent also what Sara has said, in the sense that As Michelle has already mentioned, I'm based in the UK, but due to my work with Australian Lawyers for Human Rights in Australia and also with the advisory group in New Zealand, I'm going to be building on my experiences of working in both jurisdictions. And as Sareka has very rightly pointed out, there are lots of similarities but also differences. And that's been the case globally in the sense that each and every jurisdiction builds on the lessons learned by the previous jurisdiction. And so one other point of difference I think is worth emphasizing in relation to the current developments in New Zealand is that the legislation, the proposed legislation is very much based on and is values driven, which is something that is quite unique to the New Zealand context as well. Now, before I go into the details of the proposals, the remaining proposals of our report, and also provide a bit more context of what's happening currently in New Zealand in this space, I just wanted to point out that the timing of this webinar is also very relevant as it coincides with the 11th UN Forum on Business and Human Rights that opened on Monday, and with the guiding theme on rights holders at the center, strengthening accountability to advance business respect for people and planet in the next decade. So I think it's one of the many initiatives and events that have been happening in recent years. It really helps to further elevate human rights in the context of business and as part of, if I can say, normalizing business practices that take into account human rights. It also highlights the links between business and human rights and environmental concerns. And although these are and should be seen as going hand in hand, we know that in reality that doesn't necessarily often happens. Some of the audience might have been following recent news that links the extensive forced labor and slavery in renewables supply chain. So this is, of course, hugely problematic, as on the one hand, lots have been invested, and rightly so, into more sustainable means of producing energy and tackling climate change. On the other hand, and because of current business models, including supply chains or value chains, it means those attempts often perpetuate inequality and exploitative practices. And whether that is in relation to production of polysilicon, which is used for solar panels, and we know that half of the world global production of polysilicon comes from China, and the abuses of Uyghur people and Kazakh people in the Xinjiang region in northwest China being exposed now on a number of occasions, or whether we're talking about mining of cobalt, which is essential for development of batteries in places such as the Democratic Republic of the Congo, where we know that children, often as young as 7, are routinely used as laborers. There could be other examples. So very rightly, the newly appointed, or shall I say recently, relatively newly appointed New South Wales Anti-Slavery Commissioner, Dr. James Cohane, that really what we need is urgent action. Otherwise, modern slavery risk will significantly complicate the just transition to decarbonized economy. So it will really affect whether and at what cost we can deliver on the promise of sustainable future for all, which is the underlying aim behind the 2030 Agenda for Sustainable Development. And so once again, going back to what I said earlier, the 11th Forum on Business and Human Rights, it really touches on a lot of those aspects, the linkages between human exploitation, but also environmental degradation, something that Rebecca already highlighted. So zooming back onto New Zealand, Rebecca has already provided the statistics. We know that modern slavery, different forms of modern slavery affect everyone globally. So this is not, in that sense, there is no region of the world, a country jurisdiction that is free from either directly or indirectly through the supply chains and the use of global supply chains. But focusing on exploitation of migrant workers, which is a specific and issue that's been looked into both by the government and a number of studies have been produced to show that migrant workers are a particularly vulnerable group along with international students in New Zealand. Now, in the recent times, in addition to the current legislation that has been currently proposed, there have been developments, legal developments, and further resources have been provided by the government as well. Last year, the government designated additional 50 million New Zealand dollars in funding to combat exploitation, alongside changes to the law, including creating emergency visa so migrants could leave their employers in a lawful manner. There's been also a hotline that has been set up for workers who need help. More recently, there has been introduction of an accredited employer work visa, which basically requires employers who want to hire migrant workers to go through certain checks before they can do so. This is important in a country where majority of some of the industries that Rebecca has already mentioned that have high risk modern slavery, predominant workers, migrant and short-term workers, predominantly from the Pacific. Now, all of these are important developments. However, people, in particular migrant workers, I've already mentioned, continue to be exploited by unscrupulous employees and employment agents. So the practicalities of it need to be taken into consideration as well. So you might ask, why do we have those positive developments, but at the same time, they don't seem to necessarily directly or at least mitigate some of the aspects of modern slavery in New Zealand, but not completely. Now, going back to the example I've just given of the accredited employer worker visa, what needs to be understood in the kind of from a practical point of view, that the ministry that is responsible for those checks, the Ministry of Business, Innovation and Employment, MBE for short, they have funding for some checks, but not all of them. So what it means is if the government accreditation is often based on paper. So what the employers provide and tell the government that they're doing, and in terms of what they attempt to do in order to have the permission to employ and hire migrant workers. So in many ways, it is still possible for employers to get around such paper-based accreditation and unfortunately continue to exploit vulnerable workers. One of the issues that have been raised on a number of occasions in New Zealand, but also in other countries that have similar provisions in place, is tying employment or visas with employment, because it's always going to create an environment conducive for abuse, simply because it creates significant power imbalance between the employer and the employee. The response of the government usually in favor of those arrangements, and that's been the case in New Zealand as well, is that it's necessary for migrant workers to be employed in specific areas to support the country's economy. However, that should never be done at the expense of the most vulnerable in the society. So really what we need is a much more robust system that requires more transparency, disclosure. We already discussed that, oversight and accountability, and that also includes remediation for harms caused. So this is the reason why our report focuses so strongly on victim-centered or rights-based approach to regulating modern slavery. And remediation mechanisms have been mentioned both by Rebecca and Sara as very important, because despite the fact that this has been already agreed that this is a good practice, and that's also in keeping with the United Nations guiding principles on business and human rights, UNGPs, not many legislative acts actually provide for access to justice to victims. And just to clarify, I use the term victims as a legal term, not in any way to devalue the agency of survivors of modern slavery. So when we're talking about labor exploitation, workers should not need to rely exclusively on voluntary remediation processes offered by businesses. And then we have those in place, they can work, but we know it's not sufficient. So in that sense, that's the reason why we have advocated for very strong and specific calls of action for workers subjected to modern slavery to seek redress. And when we talk about redress, we're both talking about compensation as well as other forms of support in the event that the entity might have failed or did fail to exercise a due diligence to prevent modern slavery, both in their operations and supply chains. There have been calls made globally now for compensation funds to provide an appropriate remedy to people subjected to exploitation by companies, either through the operations or supply chains. And the benefits and the urgency of such a scheme, they have been already raised on a number of occasions, including in Australia, with Anti-Slavery Australia. So this is definitely something that has been discussed in New Zealand as well, and definitely needs to be further considered, not only in New Zealand, but much more widely. Because ultimately, when we're talking about migrant workers or exploited workers, raising awareness of their rights is critical, but not sufficient on its own. What we really need is a system in place that supports vulnerable workers, including their ability to make claims for abuse and if they experience abuse and exploitation, as well as shifting the burden of proof onto the company to show that they have complied with the law. And there are a number of reasons for it, including the access to evidence and data is often limited, if not impossible, for many of the people who have suffered from modern slavery. So this is only right. That is, the burden is on the companies to show that they have complied and that they have done reasonable due diligence. On a number of occasions, we've already mentioned Anti-Slavery Commission and the need for it. I don't think that that is a particularly controversial issue in a sense. It's been widely accepted that this is a key feature for any anti-modern slavery legislation. And obviously, when we say Anti-Slavery Commission, what we mean by it is a well-resourced and independent regulator, whether that office is called Anti-Slavery Commission or something else, that is really irrelevant for the conversation. But it really needs to be free from and not subject to the control or direction of any government agencies in the exercise of its function. Something also that Sara has mentioned from her own experience, the length of time there in office is important because that really allows the commissioner to take action and to make a difference to the victims of modern slavery. Under this, the current review, statutory review of the Modern Slavery Act in Australia, the Commonwealth one that Rebecca has already mentioned, the government itself suggested a number of functions for such anti-slavery commissioner, because there is none at the moment at the Commonwealth level, the federal level, but there is anti-slavery commissioner under the New South Wales regime. So obviously, within this short period of time, it's been quite clear that there is significant benefit to having anti-slavery commissioner to ensure that could range from examining whether entities complying with the requirements of the legislation, even to recommend imposition of penalties or helping with the conduct of periodic reviews, etc., etc. So I cannot imagine that we could have an effective system in New Zealand without having an office of slavery commissioner for the very reason. An advisory group is part of that package because it really is auxiliary role is to provide expertise on the specific areas to the government to ensure that it's up to that the act, once implemented, is really responsive to the emerging issues, both in New Zealand and internationally. And obviously, the group itself should comprise of those with specific but also complementary expertise and be representative of all the stakeholders within the society, including the most vulnerable, such as workers themselves. Now, penalties, it has been and it's going to continue to be a controversial matter. And for various reasons, though, we have now had many more, if you like, more open conversation about penalties. That penalties are really necessary part of the next step, if you like, or for us to be able to ensure compliance with whatever the obligations might be. And when we're talking about penalties, they could range from those convicted of migrant exploitation, for example, being put on a public register. We could be disqualified from managing or directing our company. We could be talking about financial penalties, etc., etc. Now, one of the criticism against penalties, and obviously, understandably, businesses are to some extent, I'm not necessarily always and fully, but to some extent reluctant to have penalties introduced. But one of the criticism is that there is no conclusive evidence that actually tougher penalties will stop exploitation from happening in the first place, and that is true. But what we also know, Michelle, you mentioned the review in the UK. Rebecca, you also mentioned the review of the operation of Modern Slavery Act in Australia, which really shows that even when it's not, so speaking of the experience in Australia, it's not a voluntary, it's actually mandatory system. Nevertheless, there are no penalties attached, so there will be no real enforcement of it. And we know that only 27 of reviewed companies demonstrated any action to address modern slavery risks by elevating working conditions among the suppliers, or tackling the root causes of modern slavery. So that was a report led by the Human Rights Law Centre earlier this year. That was published earlier this year, and actually this month, there's been a follow-up report published, which again shows that 56% of commitments made by the companies in the first round to improve the modern slavery responses remain unfulfilled in the second round. So I think it really, what we have reached is the place where, yes, prescriptive or some form of voluntary approach is necessary, but also, and very importantly, more mandatory approach is necessary, including penalties. The final recommendation in our report is in relation to import bans, which is really, from our perspective, it is an integral part of any anti-modern slavery legislation. Because in order for businesses to undertake effective due diligence of their operations and supply chains, and that includes identifying and addressing the salient risks, it requires from the government to introduce a ban on the import of goods that we know are being produced by forced labor, wherever that might occur. There is sufficient evidence showing that this can be done and can have an impact, practical impact on the workers' life, whether that is based in the country where the ban is introduced or elsewhere in the global supply chains. Sara did mention United States, Canada, and they've been doing that as well. There have been recent conversations in Japan and some other countries along the same lines. Now, for New Zealand and Australia, the matter is highly politicized because a lot of the evidence that we have in relation to China, it's also because of geopolitical location of New Zealand and Australia. It means it might be more practically difficult to introduce some of the bans to the extent that has been done elsewhere, but obviously civil society and those who have workers' rights and anyone else's in mind will continue to advocate. Only last week, a bill to amend the Customs Act in Australia to ban import of goods made with forced labour was introduced in Australia and to Australian Senate. So I think this is definitely something that will come back again and again in perspective of the context within which it's being discussed. Now, so just to sum up, so the 10 recommendations from our report, in many ways, are those that have been followed and recommended generally on a more global level. And obviously, they need to be adjusted to the relevant context, national context, cultural context, etc. And in many ways, New Zealand is an indicator of, in that sense, where we are and the direction we are heading. So, taking into consideration developments in New Zealand, because I do want to finish on a positive note there, as well as globally, I think we really have reached the necessary political momentum to bring about the necessary change. Simply by looking at the number of legislative reforms and changes that have been introduced in recent years, and also those who have been looking to developing on the process of developing such legislation, New Zealand being one of them, Netherlands is another one, but also South Korea, as well as Colombia, where there have been interesting developments, because in Colombia the focus has been very much both on human rights and the climate change, so very strong on social environmental practice in that respect, which is very, very encouraging. And I think we're going to see more of it in due course. As Sara did mention in the foreword to our report, legislation is not a silver bullet. So putting differently, law, it's not sufficient on its own, because what we need is a wider culture change, which obviously is and can be instigated and encouraged by those legislative changes. But we really need a significant change the business model we currently have. So on that point, and I'm going back to supply chains, because for entities and especially private sector to regulate their own operations is somewhat easier than within the supply chains, than their supply chains. But nevertheless, aligning supply chain processes with relevant legislation, anti-modern slavery legislation, encourages structural change. Otherwise, it simply becomes an information provision exercise, which is devoid of adequate solutions that can provide for any options for preventing as well as remedying modern slavery when it occurs. So, to answer the question in the title of our seminar today, yes, we definitely need to encourage the mix of approaches with voluntary, prescriptive, and mandatory, both national, regional, and international level, that will provide us with most likelihood of success in mitigating and preventing modern slavery wherever it occurs. Thank you.
Thank you very much, Natalia, for sharing us your experience and academic expertise. I must say, I would have two questions, and possibly would be happy to hear again Rebecca on this. And those two questions would be, first, what are the chances of success of your recommendations in New Zealand and in other countries? And the second question, how do you see the role of consumers?
Definitely. Thank you so much, Rebecca. Yeah, I completely agree with Rebecca on that point, and because law is not static. And so that's why it's so important that it's not only that we have legislation passed at domestic level, but also we have a review of that legislation, so it remains current. That's been the case at the Australian level. So as I said, in the Commonwealth, just to compare with the New South Wales regime, initially the threshold was much lower, half of what the Commonwealth is currently prescribing. Also, anti-modern slavery commissioner is part of the New South Wales legislation, which is not part of the Commonwealth legislation, as well as initially penalties were prescribed under New South Wales legislation. That had been unfortunately amended, but the conversations about what can we learn from the other practices and how can we improve on the current legislation are very, very alive in Australia. And I would be very, very surprised if we didn't see an introduction of anti-slavery commission at the federal level. I'm really hoping for some form of enforcement through penalties as well. So we definitely, as I said earlier, each and every jurisdiction builds on lessons learned elsewhere. And so that also applies to within the same jurisdiction. So even though the legislation in New Zealand might not cover both human rights and environmental due diligence, but I think in time that will change. This is approach taken in, for example, in Germany, the German legislation at the EU level, the Directive on Environmental and Human Rights Diligence. Very recently, also Bill for Responsible and Sustainable International Business Conduct was introduced to the Dutch Senate, House of Representatives, and that covers both and aims to address human rights, environmental, and climate harms. So I think we're definitely going to see more of it, and along with it, probably in some time in the future, that conversation will reopen in New Zealand as well. Now, on the second question on the role of consumers, we do have a lot, and we can change. We can change how things are being done. Last year, through Australian Lawyers for Human Rights, we organised a webinar where they very much focused on what action as individuals, but as citizens and as consumers, we can take to address modern slavery. And the reality we are facing is that most things that we buy, most things that we consume had some footprint of modern slavery somewhere in the world. Now, what does that mean is that by our choices as consumers, we can put pressure on companies or on businesses to do the right thing. So we as consumers do have quite a bit of power to make things better and to make a change. So I definitely would encourage anyone who feels that there's it's necessary, as I said, to ensure that no one anywhere, wherever they are based in the world, is not exploited because of business practices, to pay more attention to what they buy, what they're buying from, and trying to find out the ethical stance of those businesses before they purchase from them. In these days, there are many many apps that allow us to make much more informed decisions, much more than many years ago. So it's not necessarily requiring individual consumer to go on a website and register, let's say, and read the statements of each and every company. So there are now ways for us to make the conscious decisions, what we buy, how we buy, who we're buying from. And in that way, we really do contribute to that change. Oh, I can see, Michael, your comment. Apology. Of course, I will make sure that I speak slower. Thank you. So this is the key points I would like to say in relation to those two questions. Both of them are very valid and very good questions. So thank you for whoever asked those two questions.
Thank you very much. Another question. How do business companies react to your proposals? Are they willing to go along, or are they resisting?
Yeah, so just to build on what Rebecca said, from my own experience, and this is often a misconception that businesses will resist, are going to be the ones that will have to be dragged into doing the right thing. and working with businesses directly through my work in New Zealand, in Australia, and also working with my colleagues and listening to my colleagues who work with businesses directly. Majority of businesses are very accommodating, and they understand that we need a change. We cannot, same as with environmental impact, we cannot continue doing business as usual anymore. Because the planet will not be able to sustain us, and in that sense, the business model that is based on exploitation of people because they might be based overseas is no longer sustainable either. So whatever the motivations of businesses, and also things like branding and pressure from consumers, because we touched on it earlier, all of those factors mean that businesses overall are going hand in hand and really engaging in this conversation. So I think that is very positive and very encouraging. The details, this is something that obviously needs to be worked out, and again, more a practical point is that we don't really have a fix or kind of idea of how to fix the problem. If we had that model in mind and we knew that it's going to work, we would have introduced it a long time ago, right? So something that Sara has mentioned earlier, do we know, is there evidence that due diligence will work? And this is the reason why we're pushing for due diligence, the majority of us in the civil society and academia, is because there is enough evidence to show that if you just do transparency, and you often, that allows entities to engage only at the surface level with the problem. So really what due diligence allows us to do is to dig in and look, and for the companies to understand what happens, what corporate impact they have, and what happens within their supply chains. Because we also have to take into consideration historical developments. Globalization of supply chains led to lack of visibility or hence transparency of supply chains. And this is not necessarily something that has been required from companies to know. Most companies would know maybe the first tier because they would have contractual obligations, but they would have no clue what happens down the line, if you like, or further down their supply chains. So this is a learning curve for everyone. So it's not necessarily that businesses have the practices or processes in place to introduce. This is not necessarily lack of will, but a lack of capability, a lack of know-how and how to do it. And so hence Rebecca mentioned, when we're talking about small, medium enterprises, they do have less resources than some of the multinationals to engage with it. And so we need to make sure we take businesses with us rather than introduce this as against businesses. It really is about leveling playing field for everyone. And I think it's now fully understood that, as I said earlier, business as usual is no longer sustainable. And in many ways, it requires a shift in thinking, because businesses, irrespective of the size, they've always been doing business risk analysis, because otherwise we wouldn't survive as a business. What are we asking now businesses to do? That risk analysis includes human risks and potentially, in some contexts, also environmental risks. So in many ways, what is new is what we're asking the businesses to look into and look for, but not actual risk analysis, which all businesses have been doing, and this is part of and parcel of running a business these days.